Well, we're joined now by Francis Boyle. Francis is a professor of international law at the University of Illinois. We're speaking to him from his office there in Champaign, Illinois. He's been an advisor to the Palestine Liberation Organization, and he's also had experience, amongst many other things, he's had experience with an extradition request by the United States to Great Britain, and that's why we're welcoming Francis in tonight to talk about that. Welcome, Francis. Thank you for joining the online vigil for Julian Assange.
Well, thank you very much for having me on, Joe, and I simply commend you and Consortium News for staying on top of Assange's case. This is critical for freedom of speech, freedom of press, journalists all over the world.
Well, I thank you for that, friends. It certainly is. You're absolutely right. So tell us about your experiences working on a case of an extradition request the United States made to Great Britain.
Right. Well, first, John, I do have to say I am not involved in this case. I don't represent Assange. I'm only speaking for myself here in my personal capacity as a professor of international law. But yes, I was involved, spearheaded the campaigns to defeat the U.S.-UK Supplementary Extradition Treaty of 1986 by Maggie Thatcher. And I won't go through all that here, except that we castrated that treaty. And then second, after 9/11/2001, the British government re-tendered the original Maggie Thatcher extradition treaty in 2006 to the Bush administration, who accepted it. So working with my brother, Jerome, who's a lawyer in Chicago, we organized every Irish-American group in the country, as well as the ACLU, to fight back against this treaty. And I won't go through all of that work here, because it is and can be found and documented in my book, United Ireland Human Rights and International Law. And I wrote it up expressly for lawyers to use in order to defeat, here in the United States, requests for extradition by the British government, especially of us Irish. Now, to make a long story short, we did fight back in the 2006 Supplementary Extradition Treaty. We were unable to castrate it. We were sold out by Irish American officials, like Joe Biden and Chris Dodd and others in the Senate. But we did get fall back basic human rights, civil liberties protections for Irish and indeed all people in the United States. Regretfully, and for whatever reason, the same thing was not done in Britain. I guess because the Prime Minister at that time was Tony Blair. He was said to be the human rights Prime Minister, which, as we all know, is a joke and a fraud. He controlled Parliament, and Parliament enacted domestic implementing legislation for the 2006 extradition treaty, exactly the way the British government wrote it, which is completely totalitarian. Under the terms of this treaty, in the event the United States government makes a request for extradition for Assange, it is going to be very difficult for his lawyers in Britain to prevent that extradition. And as a matter of fact, my guess is they will probably have to go and appeal immediately to the European Court of Human Rights to prevent his extradition. But under the terms of the treaty itself, it's going to be very difficult. And indeed, given the practices under this treaty, which I have followed because we were able to get commitments in writing from the British that they were not going to use this treaty to go after Irish liberation fighters from our War of National Liberation against Britain going back to the 1916 Easter Rebellion. And so I have followed the extradition practices under this treaty. Basically, the way it is set up, here in the United States, we've been able to get almost everyone we have asked for under that extradition treaty. Though I recently sent to you the first major exception to that might be of assistance to Mr. Assange, but that's it. By comparison, when the British have pointed out that, this is unfair that here in the when a request is made by Britain here in the United States, under the crawlback protections we got for everyone here, it's not automatic. Whereas when the United States makes requests to Britain, up until this latest exception I just sent you, it has been almost automatic. Indeed, it's basically a political process under the treaty, if I remember correctly. And again, understand, I'm just going here off the top of my head. I have not researched this issue with respect to Mr. Assange, because I'm not involved in this case. But the decision to extradite is purely political, made by the Home Secretary. Well, we know for the fact that Theresa May's Home Secretary will just turn him over immediately as soon as she can to the United States government once an extradition request is filed. Here in the United States, they tried to do the same thing to us by saying it would be automatically determined by the U.S. Secretary of State. We fought back to get that put into the control of the United States Federal District Judge, where it had been under the previous treaty that we castrated. So that's, again, what is the danger here facing Assange the moment he steps out of that embassy. The British lawyers will have to insist that Assange not face the death penalty here in the United States. There'll have to be written guarantees from the United States government to that effect. The British lawyers will have to insist and get written guarantees from the United States government that he would not be prosecuted in the kangaroo courts in Gitmo, which, of course, they have right to do. But even if the British government were to give these guarantees, if Assange got here to the United States and was actually tried in Article 3 court, he would be subjected to a clear-cut kangaroo court proceeding, found guilty, sentenced to life in prison, and probably stuck away in one of these supermax prisons that are designed to drive the prisoners insane. And indeed, there's documentation by human rights groups that that's exactly what these supermax prisons do. So it's a very dangerous situation for Mr. Assange. I know his legal team there in Britain is first rate. I don't know all of them, but the lead counsel Garzón is the very distinguished Spanish investigative magistrate, and they had better have their papers already drafted in advance, and if necessary, go prepared to go all the way up immediately to the European Court of Human Rights to get a stay of extradition, which they can't do. The European Court of Human Rights will give provisional measures of protection. Now, the other danger here is this, however. that even if that were to be done, the British government could also decide to deport Assange back to Australia, since he is not a British citizen, he's an Australian citizen. And then the Americans could try to get him under the U.S.-Australian extradition treaty. I haven't read that treaty. I don't know what, if anything, it might say. But if that were to happen, then he would be outside the jurisdiction of the European Court of Human Rights, which Britain is still subject to now. Prior to Brexit, indeed, after Brexit, it seems they'll still be subjected to the European Court of Human Rights. So there we are today, Joe. He's in my opinion, very serious physical, mental danger, even putting aside his de facto incarceration there in the Ecuadorian embassy.
Well, let me ask you a couple of questions about the European Court of Human Rights. You said that, are you saying that it is a superior court to the highest court in Britain, that it can overrule even a judgment of the highest court?
That is correct.
Wow.
As I said, I just sent you the first case ever where now it's called the Supreme Court in Britain,
right,
ruled against an extradition to the United States. That was a major breakthrough. Assange and his lawyers could very well use that. But this has been so highly politicized in Britain, too. Courts pay attention to what the government's telling them to do. So they very well could lose in the Supreme Court of Britain. I want to make it clear, I'm not licensed to practice law in England. I can't predict, what the British courts are going to do, one way or the other. But yes, they can need to prepare immediately to take his case to the European Court of Human Rights, get provisional measures of protection to prevent his extradition to the United States while the case on the merits go on. Provisional measures of protection would be like a temporary restraining order. It does not resolve the issue on the merits. Now, on the merits of the case, sure, there are large numbers of arguments that can be made in the European Court of Human Rights against Assange's extradition, that this would violate his basic human rights under a variety of provisions of the European Convention. Now, if you look at the memorandum I submitted against this treaty to the Senate Foreign Relations Committee, that was unrebutted by any expert on the side of the British, I outlined all the objections to the treaty for violating the International Covenant on Civil and Political Rights, to which both the United States and Britain are parties to. The United States is not subject to the jurisdiction of the European Court of Human Rights, so I certainly was not going to argue that to the United States Senate. But the protections in the International Covenant on Civil and Political Rights are pretty much the same protections as found in the European Convention on Human Rights. And I go through article by article, human right by human right there as a roadmap for all the rights that, his rights that would be violated. And of course, you have officials in the United States government that would threaten to kill him. And try treason or something like that. Well, he's not a citizen of the United States. He knows no loyalty to the United States. But again, this is really for his British lawyers to decide how best to proceed here. And then they also have to consider this deportation to Australia, escaping the jurisdiction of the European Court. And then you'd be in Australia, and right now they have a right-wing government there too. So who knows what would happen in Australia?
Yeah, we see here clearly the relations between the U.S. and two of their Five Eyes partners, Britain and Australia, especially when you described how it doesn't work in the same way both ways. In other words, when the U.S. asks for somebody, they almost always get them, and when Britain asks for someone, they don't necessarily get who they want. The Lori Love case, I think, is the one you refer.
And I did want to point out, we have almost always gotten everyone we've asked for.
Yeah.
Even the Brits tried to sell this as anti-terrorism, and the Bush people did. But what happened is we used it to go after all their City of London fraudsters. And we got all of them. Even though we said originally we weren't interested in these types of people, we were interested in terrorists. And they were. And I have no brief for City of London fraudsters, banksters or financial swindlers or anything like that. We got all these people. And
you did
first
mention
exception is what I sent you, and that's it.
But you did mention one case where the UK denied an extradition request, and that was for, I believe, Lori Love, who was a hacker who was wanted in the US. So that was a great victory. But the Assange case, of course, is far different than that because of all the implications of the many, many government secrets he's revealed and many, many very angry, powerful people around the world who want to get him.
Right. Let me elaborate on it. Yes, that's an important precedent. But as you correctly pointed out, the political dimensions of this problem do not compare. As far as the United States government is concerned, Assange and Snowden are public enemies number 1 and 2. And, a hacker is a hacker, regretfully one way or the other, but the political implications there are almost nil. Yeah. So this, the political pressure here, I suspect on the British Supreme Court would be to, authorize the extradition of Assange.
Now, I'm a complete layman here, so forgive me if this is an obvious question, but does someone have to be actually in custody in order to be extradited to another country? What I'm saying is, if he's arrested on this bail skipping charge, it's unlikely he can get more than a few months for that. That's really a minor charge. Could his lawyers wait it out and that he's freed from that and could not be then extradited? Or would the British authorities take that into consideration when sentencing him, if indeed he's convicted? He's not even been charged yet, but if he's convicted for bail skipping.
Now, the moment they have custody of him, the U.S. can file that extradition charge, and that would be that, and they would just waive any prosecution for bail skipping. Right now, it seems to me Assange's best strategy, and again, I defer to his British lawyers, is to wait it out in that Ecuadorian embassy. Hopefully, the Tory government will fall. Corbyn will come to power. The Labour government, there will be a Labour Home Secretary. And then a campaign could be brought to bear on the Labour Home Secretary not to extradite Assange. That might be the best strategy.
So you mean when the U.S. files an extradition request, he could be held in the U.K. under those conditions? Under U.S. prosecution, he could be held in the U.K. pending extradition. Interesting.
That's correct.
I see.
That's correct.
You might
the moment he walks out of that embassy, that's correct. And he is actually physically taken into custody by a British law enforcement authority, yes.
So he could stay there until this is resolved one way or the other, the extradition request. Now, if they go to Europe, I think that 30 European MPs last week filed a petition or a statement in support of Julian Assange. So given that that's not a lot, 30, but it's more than we have in the UK, and certainly here in the US Congress, is the political atmosphere in Europe sufficiently different, in your opinion, to give him a chance to win in the European Court of Human Rights?
This is something I discuss with my students in my international human rights law course. And today, I think you get a fairer shot, certainly in the European Court of Human Rights, than you would either in the United States Supreme Court or the UK Supreme Court, yes. It wasn't always that way, but I believe it is today. And even if it would first perhaps start out with a panel, and then they could move for a grand chamber of all the judges. And at that point, certainly when it gets into the European Court of Human Rights, I think you're going to need a grassroots public relations campaign, not only in the UK, but also in the EU and in the European Parliament, yes, in support of Assange, because he has been so thoroughly vilified that public opinion needs to be educated and turned around, including the judges. Yes, that has to be done. I mean, all judges everywhere in these Supreme Courts read the pages in the newspapers and pay attention to public opinion polls. But right now, I believe he's going to get a much fairer shot in the European Court of Human Rights than he would in the UK Supreme Court, and certainly not in the US Supreme Court, where you have 5 Federalist Society judges on there, the 5 horsemen of the apocalypse. So obviously you'd have to appeal there, but you're not going to get anywhere. They couldn't give diddly squat about
it's 17 hours.
Let alone Assange's human rights.
Well, Francis, I just want to ask you one more thing before we let you go. I don't know how much expertise you may have in the Espionage Act, but as we probably can assume, he has been charged. The U.S. government has admitted that. They're not releasing the details yet. That's tied up in a court here in Alexandria, Virginia, where I am. So we may or may not get to see what the details of the indictment or criminal complaint. But it's been assumed that it's under the Espionage Act. And my reading of the act is from the original 1917 Act, in the Wilson administration, it made clear that only acts committed on U.S. territory or the high seas could be prosecuted. That, unfortunately, was changed in 1961 in an amendment that made it global. So this could be anywhere in the world, because Assange, of course, committed acts of publishing outside the United States. And there's also something in the original act which says that even mere possession or dissemination of classified material is actionable, can be prosecuted. Of course, Julian has never been accused of stealing the documents himself, but only of accepting them and publishing them. But the Espionage Act has never been used against a journalist for political reasons, because it appears to conflict with the sentiment, at least, of the First Amendment. There were some, of course, after the Pentagon Papers case, the Nixon administration could have gone after both the Post, the Times, Senator Mike Gravel, who published it in a book. They could not do prior restraint. That's what the Supreme Court decided. But after publication, they could have prosecuted, but they didn't, because politically it would not be the right image for the administration to go after journalists like that. And there have been similar cases like that. So I want to know, am I correct in saying that he can be legally charged under the Espionage Act, as abominable as that act is, the way it's written? And for the political reasons have stopped him, but the Trump administration being so anti-media, maybe they would actually do this, which the Nixon administration wouldn't do.
Well, again, this is speculation what they're going to do. I don't know if they would request his extradition for prosecution under the Espionage Act for the reasons you have given. And because it then would open up this whole can of worms from their perspective. So they might request his extradition for common, ordinary, garden variety crimes, theft, misuse, things of this nature. And he, in theory, then could be extradited for that type of prosecution. However, if I remember correctly, under this treaty, the British government could waive the requirement of specialty. And the requirement of specialty is that you can only be prosecuted for the crime for which you are extradited. So they could get him over here under a variety of common, ordinary federal crimes that I'm sure they could concoct without any problem. And then once he's over here, the British government could waive specialty and then, in theory, prosecute him for violation of the Espionage Act. Now, I haven't studied the Espionage Act in a long time because I haven't been involved in cases under it. But as we all know, it was originally intended to do with spying during the First World War. Spies conducting themselves during wartime to get secrets. Well, okay, fine. We can agree on that. The First World War, fine. The Second World War. It was never intended to go after journalists practicing journalism. And yet there has been a history of administrations using and perverting the Espionage Act to go after journalists and to try to use them as a cudgel over their head. And, given the Trump administration, that very well might be what they decide to do. They would want to set a precedent to use against investigative journalists, first-rate journalists, whistleblowers, and things of that nature. So we cannot rule this out at all, Jay.
Yeah.
But if we get this issue in United States courts, I'm afraid, given the current Supreme Court, the five Federalist Society horsemen of the apocalypse will probably lose. So there it is. What can I say? So I agree with what you're saying, but actually winning these issues in the United States court will be, given the right-wing nature of U.S. courts these days, it's going to be very difficult to make progress with those types of arguments.
The act makes it clear that the death penalty can only be imposed in the time of war. So I could see them stretching out that the Afghan war cables and the Iraq collateral damage videos was a time of war. And that was actually exposing war crimes by the U.S.
That's correct. And so the British lawyers will have to demand that the British government get a guarantee in writing that Assange will not be prosecuted will not be sentenced to death. It's that simple. That is, even if he is convicted, they'll have to get that guarantee. And indeed, if not, they can go to the European Court of Human Rights and get that guarantee, get the European Court to order the British government to get that guarantee. Yes. But indeed, this treaty is so bad that if you read it, that someone can be extradited to face the death penalty, but could not be executed. So they'd be, this was done deliberately and maliciously, Joe. So they could be over here, sitting on death row for the rest of their lives. Right. Although even then, the European Court of Human Rights, there's a very famous case, Soaring, saying the death row phenomenon constitutes cruel, inhuman, degrading treatment. So they could stop that too at the European Court of Human Rights. So these are, large numbers of issues. I want to make them clear. I have not investigated any of them with respect to Mr. Assange because I am not working on his case. A good friend of mine, Mike Ratner, did represent Assange in this country. And I told Mike I'd be happy to work on this case if he wanted me to. Unfortunately, Mike is going on to his reward, but I told his successors there at the Center for Constitutional Rights. So it's a highly complicated, highly charged, highly politicized situation. But my best advice is keep him out of the United States at all costs and tie this thing up over there at the European Court of Human Rights, at least until a Corbyn administration gets in there, and then launch a public relations campaign with Corbyn and the Labour Party on behalf of Assange. Right.
Thank you very, very much, Francis, for spending some time with us tonight.
Well, thanks, Joe. I'm sorry I can't be more enlightening. I'm just sort of giving you off the top of my head, and we'll have to see what happens.
I found it very enlightening. Thank you, Francis.
Okay, thanks, Joe.
Bye-bye now.
Yeah.